Welcome to The Fine Print, the podcast where we explore the law, its impact, and the people who shape it. I'm your host, Rudelle, and today we're diving into the high-stakes world of litigation. My guest today is Ms.Ling Ling Luo, a powerhouse litigator who's been in the legal field since 2008. Her areas of expertise include construction claims as well as complex criminal cases. Representing clients in high-value disputes, both locally and internationally, and serving as amicus curiae in the landmark High Court case, she's truly done it all. She's not just a lawyer, she's a fighter who takes on some of the toughest battles in Singapore's courts. So, Ms. Luo, I'd love to start with your journey. What drew you into litigation, and what do you cover in terms of litigation matters?
I was drawn to litigation because I wanted to help people in general, and I am a disputes lawyer because I felt that is the most meaningful way for me to help people around me. I've tried doing law in the government sector previously. I was a legal officer doing legal work in the government for around 4 years. I found that work very meaningful, but it took quite some time for the work to be completed, and policy work took a long time, and there's red tape and all. So I decided to come back into private practice because it is easier for me to help someone when I'm in private practice.
Thank you for sharing your journey. Especially, it's so inspiring to hear how your interest in litigation stems from the simple fact of just helping people, and shifting from the public sector to the private sector depended on that key element and value of yours. So building on that, how important is cross-disciplinary knowledge in your work? And have you ever had to learn a completely new area on your job?
I had to learn completely new areas when I was in the first 3 years of practice. But after that, each piece of work that I got was quite similar to what I've already done in my first 3 to 5 years. I was a young lawyer working for a team of partners. I was not working for one particular partner, and I was in what lawyers call a pool system, which meant that any other partner in the law firm had the right to give me work for, and I got to learn from different types of lawyers. And as a result, that gave me a lot of exposure to different areas of law. So yes, while I did have to learn on the job at the start, after that, most of the cases that I've done the same case for quite a few times.
It's fascinating to see how your learning during the job has been applied in different circumstances and throughout your journey in different cases. So given that breadth of experience, how did you manage client expectations when the public perception of a case was very negative, perhaps even before a trial?
Usually that is quite unlikely to happen because there are rules against publicity of a case before trial, because it would be sub judice for the reporters to comment on a case before the judge has heard the case and given his decision on the case. You could say that you're defending yourself or if you're suing someone, but that's all you should be saying. You shouldn't be giving too much details or giving your own views of the case to sway the court of public opinion. So it is quite unlikely for us to have to deal with that scenario where the court of public opinion is quite against your client, with the exception of maybe crime cases. But in the criminal cases that I've dealt with, most of the clients were drug traffickers or accused persons accused of drug trafficking. And there's quite a lot of public sympathy for them. And the court of public opinion is unlikely to be against these clients.
That gives a lot of clarity on the public perception of cases and how sometimes there's not a lot of negative media. So shifting focus to legislation, for listeners unfamiliar with SOPA, can you explain what it is and why it's such an important piece of legislation in Singapore?
The Security of Payment Act claims,
Yes.
The SOPA claims commonly known, it's very important for subcontractors or even sub-subcontractors because it ensures that these subcontractors pay on a timely basis. Because if they are not paid on a timely basis, they would encounter cash flow problems. And if they do encounter cash flow problems, then cause them to stop works. And if they have to stop work, they would not be able to continue with the project. So that's why this piece of legislation to ensure that the main contractor would pay the subcontractor on a timely basis. And if there's any dispute to the quality of works done, that dispute is dealt with later. Either parties can sue in court for finality or even file an arbitration claim for finality. But in the meantime, if there is a SOPA claim and if that SOPA claim is validly made, then there should be payment on that SOPA claim.
That's a very clear breakdown of what SOPA is and just ensuring rights for builders. So following our conversation on that, how do you assess whether a SOPA claim is worth challenging in court versus negotiating in a settlement?
It would depend on whether or not the other party is also reasonable. My advice to all of my clients is to try and give a fair offer at the start before you sue. In any event, my clients also have an obligation to consider settlement first before they sue, because under the law, you must consider settlement first. And you must give an offer of amicable resolution before you sue, because if you don't, you might be given adverse court orders for failing to consider mediation or amicable resolution. So in all cases, I would advise them on the most likely litigated outcome. I would advise them to give an offer that's attractive and slightly below the most litigated outcome. And if the other party would budge and agree, it would help my client save legal costs, and it would also settle the dispute much early on.
That really offers insight into the different processes of the legal world. And for most of our listeners, they might not be aware that you need to file for amicable resolution before a sue. So turning to criminal law, another one of your expertise areas, representing clients facing the death penalty is incredibly high stakes and can be emotional. So how do you prepare for these cases?
For these cases, we take a very long time to prepare for them. We would have to appoint a psychiatrist at the very start to check if our client has any psychiatric defense. Before that, we would interview the client first, and we would judge for ourselves if there's enough for us to approach a psychiatrist. After that, we would approach witnesses, and if they are willing to testify in favor of our client, we would then interview them, and we would also prepare our client's defense. And we would interview our client quite extensively. And first, we will try to draft representations for that client. And we might not stop at the first round of representations. We might write several rounds of representations. But at the end, if the last representations were to be rejected by the prosecution, then we would just continue with trial, because there's no other choice. And for those kind of cases, as with any other case, we would prepare our client for trial, explain to him what the trial process is like. We would do a mock trial with our client as well. We would cross-examine our client as though we are the prosecutor. And we would advise him the importance of telling the truth, and we would also explain to him how we can object to the prosecution's questions if those questions are unfair, or if it's a hypothetical question, or if it is speculative. So we would spend as much time as we need with these clients compared to a divorce case or a civil claim. An equal amount of time and equal amount of effort goes into such cases. And for such cases, it would be easier for the lawyer to be more detached than to feel emotionally attached to the case or the outcome of the case if you were to fail. If you keep thinking about how the client would die if you were to fail, and if you were to make a mistake and the client might die, that distraction is not productive, and that distraction is not going to help you defend the client better. It would be far better if you detach yourself from your emotions and just concentrate on the case in a surgical manner. Just treat it like any other case. find the loopholes that you can spot in the prosecution's case and apply the law as is, and don't think about the likelihood of failure, because that's not going to help you.
That's quite eye-opening on just the whole process of filing for a criminal case, as well as preparing your client mentally and emotionally. And more than anything, just being prepared as a lawyer and just balancing the emotions and the case itself. So in these high-stakes cases, how do you approach situations where the law is clear, but sometimes you may feel that the sentence might be unjust?
I would have no choice if it were an appeal, and if I had lost the appeal, and if it is clear that there is no error on a question of law, I would not be able to do anything else. I would not be able to file a criminal motion. And in that scenario, I would be very honest with my client. I would tell him or her that I have no other recourse. I have no other solution for you. And this is where it stops. And the next best thing I could do for you, if your appeal is dismissed, is to write a clemency petition. And there is quite a low chance of a clemency petition succeeding as well.
Could you maybe explain what a clemency petition is for some of our listeners?
Yes. So if a person has been given the death sentence, and if all avenues of appeal have been exhausted, the inmate who has been sentenced to death could instruct the lawyer to write a clemency petition to the president to ask for pardon. And if the president agrees to pardon the inmate and, well, in a way, change the death sentence of life imprisonment, then that inmate escapes death. But it is rarely granted in Singapore. In recent years, there have been just one occasion when it was granted.
That's quite a thought-provoking perspective, just observing to what extent the lawyers can go to help the client. And then after that, how you have to prepare your client for what comes next. Moving on to financial crimes, could you explain a little bit about what white-collar crimes are and your role in working on them as a criminal/financial case?
I love this area of work. Quite a few of my cases can't be published because those cases involve directors who received show cause notices, show cause letters from the SGX, the Singapore Exchange. And those letters give a notice to my client to show cause as to why they should not be charged for Securities Futures Act offences. So my work for those cases are usually not published because if I succeed, my clients will not be charged and the work ends there. Whereas in my early days, I was involved in the case only after my client got charged in court. And that was what I remember to be the Air Ocean case. I was representing one of the accused person, and there was a total of 3 directors who were charged in court. My client faced a charge for failing to disclose price-sensitive information, and he was also charged for insider trading. And that was a great experience because I got to witness a senior counsel, Mr. Davinder Singh, cross-examine the prosecution's witness. And I really liked the way he drilled the witnesses and forced them into a corner to agree with him. So I started to develop this passion for the law from that trial. And after that trial, I had other cases that were similar, but they were in an early stage of the case where the directors were not charged yet. They were given an opportunity to explain to the authorities why they should not be charged. And I found that it was very meaningful because I managed to help my client find a defense for each of the cases that I was assigned to work on. For each of the clients who came to me, I was somehow very lucky that they had good defenses. And it was not difficult for me to craft credible, robust defense for the authorities in those cases. And I never heard from the clients or the authorities after we submitted the representations, which suggested that the representations were accepted because my clients were not charged. And some of them involved lawyers as well, because these lawyers, they were directors of the listed companies. They were also given the same letter that the other co-directors were given, which was to explain to the authorities why certain things were not disclosed. Why was it only disclosed at a certain point in time? Why did you not disclose it earlier? So it was very straightforward issues in my view, but the clients were quite flustered initially because they didn't know what to do. But having gone through the full trial and what would happen in the trial, I was very well prepared to find a defense for my client and by interviewing them. And I managed to help them not get away, but managed to help them explain the true situation to the authorities.
Your experience is really highlighted in this particular area and how your journey has just led your clients to trust you more from just being flustered about the case to trusting you as a lawyer to handle their case and having a really good outcome.
They're the lucky ones. Yeah. There are some who are not so lucky. I had clients who got convicted, even though we were very confident that they should get an acquittal at the very least. In fact, I had one case where both the prosecutor in charge and I were equally, we had the same views about the case. We knew that the case was quite close. It was not very clear that she would get the conviction. It was also not that clear that I would get an acquittal as well. So we both shared the same view. It's really 50-50 in that case. Because in the first stage of the case, I managed to catch the 3 prosecution witnesses in lies. And in fact, it was a molest case. So 2 of the witnesses conceded that they were lying. And in fact, the prosecution had given me her police statement, which contradicted what she said in court. And that was very honorable of the prosecutor because I had no access to that statement. And if she didn't give it to me, I wouldn't have known. And I thank her for that. She is a very honorable lady. Her name is Shruti Popana. I still remember her to this day. I am very touched by her being so honest. And I thank her and she said, well, I'm just doing my job. But to me, that was very important because the system would only work if each prosecutor were like her. If they were also honest like her, I would believe that all of them are. And she's one good example. So after she gave me that police statement, I was able to then cross-examine the prosecution witness and put it to her that I will show the court that she was lying. Unfortunately, after that win, in my view, after that win with that witness, my client took the stand and he didn't do as well on the stand. And he knew right after, because after he was released from the stand, I went through his evidence with him. I asked him why he gave the answers that he did. He told me that he didn't actually understand the questions that were posed to him by the judge. He had spaced out, which was tremendous waste because if he had just listened and slowed down to just listen to the questions carefully instead of rushing through his answers, he would have done well. Yeah. So it was quite a waste. And eventually he was convicted. We appealed. We didn't succeed, sadly. We were also quite confident in the appeal, bearing in mind the success that we had with cross-examination of prosecution witnesses. So that was a case that I still remain disappointed with in terms of the outcome. I had other cases where I lost. Those are the tough ones. Those are the drug trafficking cases where the evidence is just overwhelming. There's just no defense available to your client. The worst was when they have exhausted their appeals and they have nothing else and you just have to say goodbye.
Thank you so much for just sharing about that case and really putting it into perspective, just like I was right there and our listeners were right there with you. And I think the key takeaway seems that it's just highlighting the different values of law and the subject as a whole, like the honesty and listening, which is some key core human values that might be part and parcel of this job. And I'd like to just touch on a subject that you've brought up quite a few times in this episode, drug trafficking.
Yes.
So how do you see drug trafficking kind of evolving over the next few years?
I found that there are clients who are most sophisticated nowadays. The demographics of the accused persons have changed as well. It would appear that the standard drug trafficking client is no longer Malaysian Indian or Malaysian Malay or Singaporean Indian or Malay men. There are quite a few Chinese individuals, and there's even young accused persons, and there are also quite a few elderly persons who are arrested as well. So it appears that the drug lords have shifted their targets or their strategies. They have found a different type of couriers in recent years. Not sure why. And I think that there's also an increase in the number of briefcases. At least that's what I've experienced. As a result of the increase in the number of briefcases, I could not take on as many LASCO cases as I could. Previously, I took on more LASCO cases. LASCO cases under the Legal Aid Scheme for Capital Offences. I took on quite a few of those cases as a lawyer appointed by the court to act for these inmates who are facing the death penalty. But because of time constraints, I could only take maybe 2 or 4 cases per year. I've completed 2 appeals this year, so I'm left with 2 trials, and I'm unlikely to take more in the next year for the LASCO cases. In recent years, there have been a trend of inmates accusing their lawyers of negligence. In fact, I have had a few inmates who accused me of not following instructions. It came as a surprise because, I'll give you an example. One of them claimed that I never got his approval to send the clemency petition to the president. And the clemency petition that was sent to the president was done without authorization. I was quite shocked to see that kind of a complaint. I was told to explain myself, and my explanation was very easy. I simply had to enclose the draft clemency petition that my client signed. I made him sign on each page. I made him read everything, and he had amendments to them. So he amended the draft clemency petition, and he signed against all his amendments. And I managed to get a witness with me to witness me doing all this with my client. All I had to do was to write a letter to court enclosing that copy of the draft that my client had signed to show that he was just lying to the court. He had lied to the court staff to say that the clemency petition was sent without authorization, and I had good records to show that. Imagine if I didn't keep records. That would have been horrible, because then it would be my word against his word. Well, it could have bought him some time. Maybe that's what he wanted, just to buy time. But it was not right for him to have lied to buy time. So for these clients, I used to feel angry. But just this year, I've changed my view as to why they behave in this way. I can see the desperation that they have because they know that the execution will be coming soon. What if there was genuinely a miscommunication between lawyer and client? It is not impossible. So I kept an open mind. I would listen to my clients. I would try and test them to see if what they're saying is true at the very least. And if it does appear that there is quite a strong likelihood that there might be some miscommunication, I will not give up on them so easily. I might try and persuade them to withdraw an application to adduce fresh evidence in the form of their testimony on the case that they had wanted to run, as opposed to the case that their lawyers have advised them to run. I might advise them to withdraw the application if the notes from the lawyers show that the client did not say what he claims he said. But if the client refuses, I don't have a choice, actually. I don't have a choice, and I just have to continue with his application anyway. And that was what happened this year. I went to court. I could not withdraw the client's application because he refused to. So I had to continue. His application was that he wishes to give his testimony on a partial consumption defense. And he's saying that his lawyers read different defense that was detrimental to him. So his lawyers had a different story. His lawyers claimed that he didn't say that. I did not want to be the judge of my client. And I did challenge my client, but my client refused to back down. He refused to withdraw the application. I was stuck, and I informed the court that I was stuck. But the court wasn't so understanding. And the court wrote a judgment and claimed that it was irresponsible of me to have continued. But do I really have the choice? I don't think so. That's why I didn't withdraw the application, because I didn't get client's mandate to withdraw the application. Yeah. It was unfortunate that the case went down that way, but given another choice, I might have instead, on the day of hearing, applied to discharge myself, since I was stuck and the court is going to call me responsible in a situation where I'm stuck, which would be unfair. Then I might as well apply to discharge myself. At that time, I didn't discharge myself. I didn't apply to discharge myself because it felt wrong. It felt wrong, but perhaps at the next occasion, I might just apply to discharge myself, depending on the situation.
Thank you so much for breaking down another case for us and just showing us the key aspects of just being a lawyer. I think the fine line between a lawyer having their own autonomy as well as communication with their client to make sure that everyone is aligned on the same page is truly significant and important in this career, and also highlights the different complexities in this job. Thank you also for describing the different types of drug cases you're seeing arising in Singapore and how the suspects have changed and are continue to evolve and change over these years. It's kind of showing how nothing's set in stone. So finally, what advice would you give to an aspiring lawyer that's considering to enter these fields?
I would say that it is going to be very difficult at the start, but don't give up. Don't quit too early. Try not to job hop. Try to stay at a firm for maybe at least 2 years, because when you change firms so early, after 3 or 6 months, you will not be able to see a case through from start to end. And if you can't see a case through from start to end, your experience would be quite patchy and it is not meaningful as well in terms of learning. It would be good if you try and argue a case in court yourself. Do it with your senior sitting beside you, supervising you and assisting you, coaching you along the way is possible. So I do coach my younger lawyers to argue cases on their own. When we had video hearings, I would try and type very fast on WhatsApp and guide them where necessary. When there are rebuttals that they should make, when there's a point that is new, that they might not have thought of, but because of something that opposing counsel has said, we can leverage on that and then make our rebuttals immediately. So in situations like that, I found that it was great value add. The young lawyer gets good guidance over WhatsApp while he or she is arguing the matter. And if she's doing well, I wouldn't have to say much at all. If he is doing well as well, I wouldn't have to say much over WhatsApp too. Yeah. So to the younger lawyers or people who are aspiring to do law, I would say work hard. Don't give up too early. It's not going to be easy and it's going to be quite unpleasant, because if you do litigation work, you might have nasty opposing counsel, you might have nasty clients, you might have a nasty boss, and you might encounter, on the rare occasion, a nasty judge. So on a very bad day, you might have 4 different kinds of people screaming at you. But don't give up.
Yeah, I think, the idea of resilience is so important in this field. And I'm sure our listeners, and myself included, have learned a lot from today's episode, especially just highlighting the different values that a lawyer must have, notably honesty, communication, and just trust with your client as well. It's been such a pleasure having you on the podcast, Ms. Luo. Thank you so much for sharing your insights and cases. And to all our listeners, court is now adjourned until next session with the fine print.